Okay, everyone, this week the judge scheduled motion hearings. First, on the government's motion to amend conditions of pretrial release for co-defendant Ian Davis Austin. That hearing is now set for July 22nd. The government wants tough release conditions imposed or reinstated. It's not clear what the current release conditions are. According to the federal public defender, the court imposed minimal restrictions across the board, a stay-away order regarding City's Church except for defendant William Kelly, aka Dowoke Farmer, who additionally has to report to pretrial services and submit to a mental health evaluation. But the government says, wait a minute, co-defendant Ian Davis Austin initially had conditions imposed in February, including that he not violate any federal, state, or local law while on release. Now, last month, Austin was arrested twice in New Jersey during the anti-ICE protests there at the Delaney Hall Immigration Detention Center. No other co-defendant has been arrested at an anti-ICE protest since being indicted for the invasion of City's Church, including Don Lemon, who's scarcely covered an anti-ICE protest, even from a distance, on his YouTube channel since being indicted. Now, he did do a show about the New Jersey protests, but from his studio, and his guests, whom he interviewed, appeared from their studios. No on-the-ground reporting from Don Lemon in New Jersey, and certainly no further attempts to empty out a church just because a field director for ICE is a pastor at the church. Now, presumably, we'll find out after the motion hearing the current whereabouts of co-defendant Ian Davis Austin. Was he detained by New Jersey on the state charges for disorderly conduct and endangering another person? Now, he's a defendant with at least 2 open criminal cases for the same type of conduct. The U.S. attorney in Minnesota and the government's trial attorney in the City's Church case is asking that co-defendant Austin be supervised by pretrial services, that he actively seek employment, no firearms, destructive devices or weapons, no excessive alcohol consumption, no controlled substances unless prescribed, submit to drug testing, etc., etc. A lot of release conditions. His defense attorney says he's already receiving psychiatric treatment. So the question is, can he be convinced to conform his conduct? Don Lemon, for example, is keeping a physical distance from anti-ICE protests and seems to be limiting his on-air discussions about the issue as well, since his statements could be used against him in the City's Church case. That only stands to reason. Now, if co-defendant Austin refuses to conform his conduct while on release in 2 open cases, it would be unusual. It would set him apart from every other co-defendant. Now, Don Lemon spent 1 night in jail after his arrest, and that was enough for him. Now, in a big case like this with 38 defendants, and until now, none of them going near anti-ICE protests since being indicted, it seems the government's approach has worked. It's tough to argue with what works. Now, if Austin doesn't conform his conduct, he will be setting an example going forward. Now, these photos are from the New Jersey protest. It's an encouragement to build a rap sheet that will follow the protesters their entire lives. In contrast, the rest of the co-defendants in Don Lemon's case are conforming their conduct, and the criminal justice system is all about that. The government doesn't want to jail everybody. If everyone jails the baser instincts in ourselves, that's freedom. It's not this. Now, the 37 co-defendants who are conforming their conduct value freedom. We couldn't tell that before when they invaded a church and drove the congregants out and chanted, "Who shut this down? We shut this down." Now, at that time, we couldn't tell that they valued freedom, but we can tell now by their conduct. Now, the judge also set a hearing on co-defendant Georgia Fort's motion seeking immediate disclosure of Brady materials. That motion was joined by co-defendant Michael Walker Butte, who's Don Lemon's camera operator. The hearing is set for July 24th. Now, after Georgia Fort filed the motion a couple of weeks ago, the government voluntarily disclosed to the judge grand jury testimony from one witness and disclosed it to the defense as well on the ground that it's Brady. Then the defense shared it on the public record. As I mentioned in a previous video, in my view, the material isn't all that Brady. The witness testified to the grand jury that he did not feel physically threatened by Georgia Fort. That's the Brady material. Now, which doesn't contradict the indictment. necessarily. And the witness also testified he was surprised by the bad behavior of the journalists. Later, the government voluntarily disclosed in camera to the judge only in chambers additional grand jury material regarding Georgia Fort. We don't have access to that material yet. Now, all Brady material has to be disclosed to the defense. Defendants have the right to obtain exculpatory evidence, even if it's grand jury material, which is typically kept secret. But the government has to recognize the material as Brady before the disclosure, and the recognition isn't always instantaneous, especially if there's a huge volume of discovery and the human brain, being what it is, unique to each person. So the grand jury witness's testimony about not feeling physically threatened by Georgia Fort, yes, I would concur that it's Brady, but not instantly recognizable as such. In my view, for example, it's not the low-hanging fruit. Now, Georgia Fort also speaks about search warrant applications that were denied, which apparently accused Georgia Fort of actions for which she wasn't indicted, such as chanting anti-ICE slogans such as "ICE out," "hands up, don't shoot," etc. Now, the defense denies she did those things and says the government may have told the grand jury about such actions of the defendants that didn't make it into the indictment, and because they didn't make it into the indictment, they were obviously false statements. Come on now, the government has said new charges could be added. The search warrant applications were denied early on in the investigation. The defense is arguing that because a search warrant application was denied, it must contain false information. Really? That's not logical. And even if it did contain false information, how does the defense know that it was shared with the grand jury? How would the judge who denied the search warrant application know what occurred or didn't occur? No fact in the case has been proven yet, including defense contentions about what their clients did or did not do. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.